The next case then is the Sohamaxa people versus Paraguay. And these people were displaced. Their community was living on the side of a road, a highway, because their lands had been taken from them, and the lands were being considered as private lands. And so these private lands were there, and the Sohamaxa people were not able to access those lands any longer. Very much like the Hulkaminum case that we're involved in, where the lands have been largely privatized, and therefore, you no longer have access. Here, the court said that traditional possession of their lands by indigenous peoples has the equivalent effect of those of a state-granted full property title. Now, again, it's a much different approach. The approach is one that you don't have to go to court and prove it. That the traditional possession of your lands entitles you to full property title. That traditional possession entitles indigenous peoples to demand official recognition and registration of property title. The members of indigenous peoples who have unwillingly left their traditional lands or lost possession maintain their property rights even though they lack legal title unless the lands have been lawfully transferred to third parties in good faith. And the members of the indigenous peoples who have unwillingly lost their lands, where those lands have been lawfully transferred to innocent parties, are entitled to restitution, either to obtain other lands of equal extension and quality, or that possession is not a requisite to the existence of their rights. So even though they weren't in possession of their lands because they were effectively told to leave, they still retained their land rights. The next case is the Yakaxa people versus Paraguay. And this is sort of the same situation that these two communities were affected in Paraguay. And again, these private landowners had moved in, taken over their lands, that the indigenous families were dispersed over many areas, were mistreated, exploited, and that the state had failed to acknowledge their land rights. Here, the court said this: it is necessary to take into account that the land is closely linked to their oral expressions and traditions, their customs and languages, their arts, their rituals, their knowledge and practice in connection with nature, culinary art, custom law, dress, philosophy, and values, in connection with their milieu, their integration with nature and their history. The members of indigenous communities transmit this non-material cultural heritage from one generation to the next, and is constantly recreated by members of the indigenous groups and communities. And so this human rights approach is that this is very much a part of their consideration, that it's about maintaining the cultural integrity of the people, and the connection to the land is a very big consideration. While Paraguay recognizes the right to communal property in its own legal order, it has not taken the necessary domestic legal steps to ensure effective use and enjoyment by members of the Yakaxa community of their traditional lands. And this has threatened the free development and transmission of their traditional practices and culture in the terms set forth in the previous paragraph. They talk about the Paraguayan Constitution, and very much like Section 35 in Canada, Paraguay has in their Constitution Article 64, and Article 64 has a constitutional provision that indigenous peoples have the right to communal ownership of land of a sufficient extent and a sufficient quality for conservation and development of their own manner of life. The state will provide these lands to them free of cost, and these will be non-encumberable, untransferable, inextinguishable, and they cannot serve as guarantees for contractual obligations or to be rented, and they will not be subject to taxation. So many of the similar concepts to what we have under Canadian law. And Indigenous peoples may not be moved or removed without their explicit consent. They refer to the European human rights, and here's where they develop further these concepts that human rights are live instruments whose interpretation must go hand in hand with the evolution of the times and current living conditions. The court has stated that interpretation of a treaty should take into account not only the agreements and documents directly related to it, but also the system to which it is a part, and they make reference to the Vienna Convention. In the instant case, in its analysis of the scope of the convention, the court deemed it useful and appropriate to resort to other international treaties, aside from the American Convention, such as ILO 169, to interpret the provisions in accordance with the evolution of the inter-American system, taking into account related developments of international human rights law. The corpus juris of international human rights law comprises a set of international instruments of varied content and juridical effects, treaties, conventions, resolutions, declarations. In its dynamic evolution, it has had a positive impact on international law in affirming and building up the latter's faculty for regulating relations between states and the human beings within their respective jurisdictions. This court, therefore, must adopt a proper approach to consider this question in the context of the evolution of fundamental rights of the human person in contemporary international law. From the African human rights system, there's the Indoricus versus Kenya case. And here, again, the complaint was that the Indoricus people were displaced, that they argued that they have always been the bona fide owners of the land around Lake Bogoria. They argued that their concept of land did not conceive the loss of land without conquest. They argued that their pastoral community and their concept of ownership had not been one of ownership by paper. They said that they had always understood the land to be theirs as a whole and used for their cultural practices. Here, the African Commission relied heavily on the Inter-American Commission's case law and found very similar results. Again, that the Kenyan government, that the Indoricus people's traditional possession had the equivalent effect of state-granted full property title, that their traditional possession entitled them to demand official recognition and registration, that if they had unwillingly left their traditional lands or lost possession, that they maintained their property rights even though they lacked legal title, and unless the lands had been transferred to third parties in good faith, that if you had lost your lands in those circumstances, that you were entitled to lands of equal extent and quality, and so they agreed that the Indoricus people's rights had been violated. And lastly, the case that we brought to the Inter-American Commission in Washington, D.C., the Hulkamino Treaty Group versus Canada. In our case, in the admissibility ruling, the Inter-American Commission found that by failing to resolve our claim with regard to ancestral lands, the BC treaty process has demonstrated that it is not an effective mechanism to protect the right, because that's what Canada was arguing. Well, in British Columbia, you have the BC treaty process, and there are nations that are involved in that, therefore you have an effective remedy. The treaty, the Inter-American Commission agreed that this was not an effective process. It's been 21 years, and we have two treaties. They also said that, that they found that the government's position that nations that do not wish to accept their terms of negotiation can litigate. And so you go back to the comments that they had made previously, that just because you can go to court doesn't mean that the rights are protected. And they said that they noted that there was no due process of law to protect the property rights of the Hul'qumi'num people to its ancestral lands. They observed that the government of Canada had argued, well, look at all this, look at Calder, look at Delgamuukw. It demonstrates that our legal system is effective, that our legal system is fair, that the Hul'qumi'num people will get a fair shake if they go to court. The commission agreed with us that there has been no legal case on Aboriginal title that has been favorable, and they agreed that none of the cases that were argued seem to provide any reasonable expectation of success because Canadian jurisprudence has not obligated the state to set boundaries to demarcate and record title deeds of land of the Indigenous peoples, and that these remedies would not be effective under recognized principles of international law. So as a result of that, they found that there was a prima facie case that moved us forward to the merits that Canada was violating the Hul'qumi'num people's right to equality, the right to religion, the right to culture, and the right to property. So we can see that these two legal systems, the domestic legal system and the international legal system, are really dealing with the same topic, but they're going about it in very different ways. Under Canadian jurisprudence, it's this slow building case upon case, precedent upon precedent, that are taking many, many, many years to try and resolve. What's going to happen in the Williams case, we're not sure. Whether the Supreme Court of Canada will agree with the BC Court of Appeal, and that is that First Nations are only entitled to have property rights to these very small areas and not to territorial areas, or whether the Supreme Court of Canada will in fact begin to look at a much more progressive way of dealing with Indigenous land rights, such as is being developed by the international human rights system in terms of looking at a much broader scope of rights and how to resolve those rights, and saying that states like Canada have an obligation to establish effective systems. Is it effective when it's taking the Chilcotins have been in court over 20 years? The Hul'qumi'num people have been at the negotiating table for over 20 years. So are these really effective? So those are some observations in terms of this issue of domestic and international jurisprudence. And I want to thank you for coming out this evening and listening. Just one little plug. We did incur costs by going to Ottawa. We're trying to offset some of those costs still. We do have some T-shirts over here that we're selling. So if anybody's interested, you can come over to the side table when we're finished. Got through this great big presentation.